What happens when a drunk driver who literally rolled her car on the freeway gets caught violating her bond again? Today, we're diving into the case of Angel Wilson, who's about to learn that judges have zero tolerance for repeat offenders playing games with court-ordered sobriety monitoring. She's claiming her SCRAM ankle monitor malfunctioned, but with blood alcohol level that could have killed her and a previous violation already on record, this judge is not buying it. We're about to witness a defendant's desperate attempt to avoid jail while her attorney tries every trick in the book. Will the judge show mercy, or is Angel about to get a reality check behind bars? Let's find out.
Court does call the case People versus Angel Wilson.
Assistant Public Defender Natalie Pate for Miss Wilson, who is approaching. Please state your name for the record, ma'am.
Angel Wilson.
Okay. What are we doing?
Your Honor, there is a resolution in this matter to which Miss Wilson will be pleading to added count 2 of operating while visibly impaired, and in exchange, count 1 will be dismissed.
That's an operating while visibly impaired.
That is correct.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Angel Wilson.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor. It is punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services, order any rehabilitative services or community service the court deems necessary. Do you understand that?
Yes.
Okay. Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Hold up. Let's talk about this plea deal real quick. Angel's pleading guilty to operating while visibly impaired, which is actually a lesser charge than what she was originally facing. This is a classic prosecution move. Offer a reduced charge to avoid trial and guarantee a conviction. She's facing up to 93 days in jail. But here's what's interesting. The judge mentioned emergency services costs. That means taxpayers had to foot the bill for her rescue when she rolled that car. The fact that she's taking this deal tells us the evidence against her must be overwhelming. But watch what happens next. The judge is about to extract the brutal details of exactly what she did that night. And trust me, it gets worse.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
Yes?
Yes.
All right. You signed an advice of rights form today?
Yes.
Any question regarding any of those rights? Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation?
No.
Are you on parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead guilty?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense? August 7, 2023, at the location of US 23 near Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes.
What did you have and how much?
I don't.
You don't remember?
How much alcohol?
Okay, how much?
No.
What did you have?
Tequila.
Tequila? Were you stopped by the police or was there an accident?
An accident.
What happened?
The car rolled over.
Pardon?
The
You need
car.
to speak up, young lady.
The car rolled over on the freeway.
All right. That didn't spontaneously happen. What did you do?
I lost control of the vehicle.
And you rolled it.
Yes.
Did you catch that pause before she admitted to drinking tequila? And now we know the truth. She rolled her CAR on the freeway. This wasn't just a fender bender. This was a potentially fatal accident that could have killed innocent people. Notice how the judge said, that didn't spontaneously happen. That's judicial sarcasm at its finest. He's forcing her to admit on record that her drunk driving directly caused this catastrophe. She's tried to minimize it by saying she lost control. But let's be real, when you're drunk on tequila and flip your car on a highway at 4:20 a.m., you didn't just lose control. You made a series of terrible decisions that almost cost lives. And we're about to find out just how drunk she really was.
Did the police and paramedics arrive?
Yes.
Were you taken to the hospital?
Yes.
Were you given a blood test?
Yes.
What were the results?
That I don't.
Was it 0.84?
The defense would stipulate to 0.84, Your Honor.
Do you have any reason to dispute those blood test results?
Me? No.
Yes. No? Go ahead. Do you have any reason to dispute at all those blood test results?
Oh, yes, I do agree.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
July 10th at 9 a.m.
July 10th, 2024, 9 a.m. I have another bond violation.
Boom. There it is. I have another bond violation. This is where everything goes sideways. Angel was already on bond with conditions, meaning she was supposed to stay sober while her case was pending. But hold on, let's talk about that blood alcohol level, 0.084. That's just above the legal limit of 0.08. But here's the thing. If she rolled her car, she was clearly too impaired to drive regardless of the number. Now she's violated her bond again, and the judge's tone just shifted completely. This is no longer about the original crash. This is about a defendant who apparently can't follow court orders even when her freedom depends on it. Watch how her attorney scrambles to explain this away.
Yes, Your Honor, and I have discussed that with Ms. Wilson. She does, and I have then reached out to Community Corrections and then got the actual SCRAM report from that company. I did discuss it with Ms. Wilson. She does dispute both drinking and a tamper. She did provide me proof that she was at work as CNA during that time. Further, both in the bond violation report I received from SCRAM, as well as my client confirmed, she received a new SCRAM tether on May 28th due to it was either a software update or some sort of malfunction. She had 0 violations for the entire month of May. She got a new tether on May 28th. And then on May 31st, there was an alleged tamper that started at, I believe it was 7:10 a.m. in the morning and stopped at 10:29 at night. During that time, my client was at work from 6:54 a.m. to 3 p.m. She denies drinking was.
Oh, this is rich. The my ankle monitor malfunction defense. The oldest excuse in the book. She's claiming the SCRAM device that monitors alcohol consumption through skin had a malfunction 3 days after getting a new one, and she just happens to be a CNA, someone who works in healthcare and should know better than anyone about the dangers of impaired judgment. But here's the kicker. She's claiming she was at work during the tampering, but SCRAM devices detect tampering and alcohol continuously. These devices are incredibly sophisticated and court certified for a reason. The defense attorney is trying to create reasonable doubt, but the judge has heard this excuse 1,000 times. Let's see if this judge is buying any of this.
Drinking whatsoever.
What time did the accident happen?
I'm sorry?
The offense, what time was she at work there at that point too?
No, Your Honor. It was at 4:20 a.m. was when law enforcement arrived on scene.
So early morning doesn't really matter, does it, counsel?
She was at work, Your Honor, and did provide me a screenshot that she clocked into work at 6:54 a.m.
And so go ahead, I'll let you go.
We would be requesting a formal hearing as to the bond violation if the
Okay,
court
she'll
is.
get her hearing, but she's gonna be remanded pending that. I mean, I already have had a violation in this case.
I understand that, Your Honor, and I understand she was remanded and served 5 days for that back in. She denies alcohol use. Quite frankly, I do believe her, and I believe that this may be a malfunction with SCRAM. She did.
Wait, what? This is her second violation. She already served 5 days in jail for violating bond before, and now she's back with another violation? This completely changes everything. The judge's patience just evaporated. When someone violates bond once, judges might give them another chance. But twice? While facing drunk driving charges where she rolled a car. That's a pattern of behavior that screams, I can't follow court orders. The defense attorney saying, I believe her means nothing. Of course they have to advocate for their client. But even they have to know this looks terrible. Angel's credibility is shot, and the judge is about to drop the hammer.
Function with SCRAM. She did receive this new tether just on the 28th, and the 31st is when the alleged tamper occurred, and the alleged tamper ended at 10:39 p.m. at night. She still has the SCRAM tether on. There has been no further alleged tamper. Further, she has been to urgent care this week due to a medical issue that I won't go into too much detail with. I did provide a copy of the doctor's note that she received from that urgent care to Your Honor. We would respectfully request that if the court is leaning towards taking any action, that we set this for a bond violation hearing and that bond continue in the interim. She did enter a plea in this.
That would be fine, counsel, except for the fact that I'm now on my second violation, both involving alcohol. You want me to ignore the fact that the original incident was one where she was drinking, rolled a vehicle. She's lucky to be alive. Then I put her on this. She comes for this charge. She's drinking. She serves her time for drinking. I'm back, and I now have another violation.
Yes, Your Honor.
How, in what responsible world would I let her bond just continue pending a year?
The judge just went nuclear. She's lucky to be alive. That a judge who's seen too many drunk driving fatalities to have any patience left. He's laying out the pattern. Crashed while drunk, violated bond by drinking, served jail time, and now violated again. His question in what responsible world is rhetorical. He's already made up his mind. This is what we call the 3 strikes mentality in criminal justice. Angel has proven she can't be trusted to stay sober even when facing serious jail time. The defense attorney knows they're fighting a losing battle here. But watch, they're still trying to keep her out of jail. The question is, will the judge show any mercy, or is Angel about to be wearing orange until her sentencing?
Pending a year.
She denies alcohol use, and we believe it is a tether malfunction as you're asking for a hearing on the matter. She did enter a plea for this underlying offense and the alleged incident, and she is willing to face penalties for that.
Yeah, because, well, give me the in custody sentencing date, first of all. Changing your sentencing date, what?
June 25th at 9 a.m.
Sentencing will be June 25th, 2024 at 9 a.m. We will move that up. Got a time for a bond hearing I can do. The 25th, my bond hearing date. That's my date that I have planned, right?
The 25th is the sentencing. Yeah.
Well, but the 24th, we have trials and
Yes.
right? We'll set a bond hearing on this matter for June 24th, 2024, 9 a.m. Pending the hearing, will be set in the amount of 10,000, make it 5,000 cash. Remanded.
Let's break down what just happened. Angel Wilson, who rolled her car while drunk on tequila with a BAC of 0.084, just got remanded to custody pending her bond violation hearing. This was her second bond violation, both involving alcohol, despite being ordered to maintain sobriety through SCRAM monitoring. The judge completely rejected her malfunction defense and set a $5,000 cash bond with an in-custody sentencing date of June 25th. The takeaway? When you're facing drunk driving charges, violating bond conditions repeatedly is the fastest way to lose your freedom and any sympathy from the court. Angel went from possibly getting probation to now facing her sentencing from behind bars. This case perfectly illustrates why judges have zero tolerance for defendants who can't follow simple court orders: stay sober or stay in jail. If this case shocked you as much as it did us, smash that like button. Drop a comment below. Do you think the judge was too harsh or completely justified? And don't forget to subscribe and ring that notification bell for more jaw-dropping courtroom breakdowns where defendants learn the hard way that second chances don't mean third chances.